Good afternoon, everyone, and welcome to our today's webinar on franchising in Thailand. This is the fifth episode of our IP webinars for this year at Tilikin Gibbons. My name is Kasama Sivatanakun, a partner in IP prosecution and commercialization at Tilikin Gibbons Bangkok office. Joining me today is my colleague Jariya and associates at our firm. So let me first briefly begin with a brief introduction of our firm. Tilikin Gibbons is the leading regional law firm established since 1890, making us one of the oldest in Southeast Asia, with over 130 years of continuous practice. Our offices span in the region, including Bangkok, Hanoi, Ho Chi Minh City, Jakarta, Phnom Penh, Vientiane, and Yangon. As a full-service law firm, we have extensive experience in intellectual property law, and our trademark and patent practices are among the most active in the region. We also have a well-established franchise practice, which brings us to today's session. Over the next 30 to 40 minutes, we will cover legal framework governing franchise transaction in Thailand, the role of Trade Competition Commission and its recent enforcement activities, intellectual property considerations including trademark licensing and recordal requirements, and the practical implications of structuring and managing franchise operation. We have a lot of ground to cover today, but before I begin, we want to make a few housekeeping notes to help the session run smoothly. So this webinar is being recorded. All participants are currently on mute to minimize background noise. You are encouraged to engage us by asking questions, but please use the chat function located at the bottom of your screen. All questions will be addressed at the end of the session, but if time is running out, we will send a follow-up by email. Your feedback is also very important to us. At the end of the webinar, a QR code will appear on the screen. Please take a moment to scan it and share your thoughts. So the first thing to understand about franchising in Thailand is it doesn't have a franchise statute. There is no Franchise Business Act, no franchise legal requirement, and no single code that comprehensively governs franchise transaction. The Ministry of Commerce at various times announced plans to draft franchise-specific legislation, and there was a draft Franchise Business Act returned to legislation for further amendments in 2016, but it doesn't appear to be among the current government priorities. My colleague Jariya will now discuss with you what this means for you. So please, the floor is yours, Jariya.
Thank you, Kusama. So it means that franchise arrangements in Thailand are governed by a patchwork of general laws. The principal statutes include those listed on the screen here: the Civil and Commercial Code, the Trademark Act, the Unfair Contract Terms Act, the Trade Competition Act, supplemented by sector-specific rules, and additional legislation such as the Patent Act, the Copyright Act, the Trade Secrets Act, the Revenue Code, each touch on specific aspects of franchise arrangements. Next slide, please. So now the good news is that Thailand is a freedom of contract jurisdiction. The parties retain considerable flexibility to structure their franchise agreements however they see fit, provided that the terms do not violate the law or public policy and do not constitute unfair contract terms. A deal between parties of equal bargaining power will generally not be disturbed by the courts unless there is a clear public policy reason to do so. But here's the critical point, and this is really the theme of today's session. Because there is no single code, the franchise relationship in Thailand is shaped by the interplay of contract drafting, intellectual property protection, and competition law compliance. Each of these areas has its own set of rules, its own regulatory bodies, and its own potential pitfalls. Getting the contract architecture right from the start is essential and requires careful legal guidance tailored to the Thai regulatory environment. So while Thailand does not have a franchise statute, it does have the next closest thing. In December 2019, the Office of the Trade Competition Commission, or the TCCT, issued what are known as the franchising guidelines, formerly the notification on the guidelines for the consideration of unfair trade practices in franchise businesses. These guidelines were subsequently amended in August 2020 and again in July 2021. The franchising guidelines are now the closest instrument Thailand has to a franchise-specific code, and they are the substantive standards by which the Thai Trade Competition Commission, or the TCCT, evaluates franchisor conduct. Under the franchising guidelines, a franchise is defined as a business operation in which an entity, the franchisor, enters into a written agreement permitting another entity, known as the franchisee, to operate a business using the franchisor's models, systems, procedures, and intellectual property rights within a specified time frame or location, with the franchisee obliged to pay consideration to the franchisor. Now, as for key features and enforcement of the guidelines, let me highlight a few key features that every franchisor operating in Thailand should be aware of. First, pre-contract disclosure. The franchising guidelines impose disclosure obligations on franchisors. Before entering into a franchise agreement, the franchisor must disclose information concerning franchise fee payments, IP rights, renewal and termination terms, the model of the franchising system, including applicable payments and expenses, business model and training, information on existing and future branches in the vicinity, and the scope and restrictions of IP licensing. There is currently no prescribed format or timeline for disclosure, but the obligation itself is real. For second, unfair trade practices. The franchising guidelines prohibits franchisors from engaging in unfair trade practices, including setting unjustified restrictive conditions, such as forcing franchisees to purchase unrelated products, imposing unjustified product tying or product restrictions, such as restricting discounts on perishable goods or preventing purchase of equivalent lower cost goods, and imposing discriminatory conditions among franchisees. Third is the right of first refusal. Subject to certain conditions, the franchising guidelines requires franchisors to provide existing franchisees with a right of first refusal when the franchisor seeks to open a new branch in the vicinity of that franchisee. And here is the enforcement mechanism. Non-compliance with the franchising guidelines may attract an administrative fine of up to 10% of the income earned in the year of the offense. For offenses committed in the franchisor's first year of business, the fine may be up to 1 million baht, or approximately $32,000. Furthermore, if the offender is a corporate entity, directors or persons in charge of operations, they may also face personal liability. So although framed as guidance, the franchising guidelines do have practical legal force because the TCCT relies on them when determining whether conduct constitutes unfair trade practice. The takeaway here is clear. Even though there's no franchise statute, there is a substantive regulatory framework that you will need to comply with, and it is being actively enforced. Now, let us turn quickly to intellectual property, which is really the backbone of every franchise arrangement. When you grant a franchise, you're fundamentally licensing the use of your brand, your systems, and your know-how. So getting the IP framework right is critical. So trademarks are the critical asset. Very often, the most important component of the franchise is the trademark portfolio. Trademarks and branding serves as an indicator to the consuming publics that goods or services bearing a particular mark will have a consistent level of quality. In Thailand, trademark protection is through registration. The rights to a trademark application or a registered trademark are transferable and inheritable, and the proprietor may grant a license to other persons to use the mark for any or all of the goods for which it was registered. The critical point here that many franchisors overlook: if a franchisee or a licensee uses a registered trademark, that use must be recorded with the Registrar of the Department of Intellectual Property, or the Thai DIP, under the Thai Trademark Act. And why does this matter? Because use of a recorded license use of the mark by a recorded licensee is deemed to be used by the franchisor or licensor, a significant defensive measure in cancellation actions for non-use. So if you do not record the license and the franchisee is the only one using the mark in Thailand, you could be vulnerable to having your registration canceled. So without proper license recordation, the license agreement itself shall be deemed invalid and void. And this can have serious financial consequences, because without a valid license agreement recorded in Thailand, the franchisor may not be able to enforce the collection of royalty fees from the franchisee as well. I should also note that IP license agreements forming part of franchise arrangements require recordal with the Thai Department of Intellectual Property, and those documents must be translated into Thai. This is a practical requirement that needs to be factored into your timeline and budget as well. Both the licensor and licensee may take action against infringers, although the licensee's ability to take action is restricted by the terms of the agreement. Since Thailand is a freedom of contract jurisdiction, the parties can adopt terms they consider appropriate regarding enforcement rights, as long as the terms are not expressly prohibited by law. To illustrate to you how serious this risk can be, there was a Thai Supreme Court case where a franchisee registered copycat trademarks in Thailand while using the franchisor's brand. The court ultimately canceled those marks on the basis of bad faith, but importantly, the dispute arose because the franchisor had not secured its rights locally. So the practical takeaway is very simple here. You should register early and be very clear on ownership in your agreements. As for other IP rights, we have trade secrets as well. A franchisor must protect its proprietary trade secrets through confidentiality provisions under the Thai Trade Secrets Act. And protection is only available if careful steps have been taken to maintain secrecy. As for copyright, these may be operation manuals and proprietary software which are protected under the Copyright Act and should be addressed in your agreements. The key message here is that IP in a franchise arrangement is not a single issue. It is a cluster of interrelated rights that each need to be properly secured, licensed, recorded, and enforced. So failing to do so can have consequences ranging from loss of trademark rights to unauthorized disclosure of trade secrets. So in short, IP is the foundation upon which every successful franchise is built. This is an area where many franchise disputes stem from. And if you get this wrong, the entire business model could be at risk. Now, let me touch briefly on some of the key commercial and legal considerations for structuring franchise agreements in Thailand. Firstly, governing law. There's no requirement for franchise documents to be governed by Thai law. Parties have free choice of governing law. However, the enforcement of foreign judgments in Thailand may be challenging, as Thailand does not generally enforce foreign court judgments, including injunctions. This is a significant consideration for international franchisors thinking about dispute resolution. As for arbitration, arbitration is recognized as a viable mean of dispute resolution, and Thailand is a signatory to the New York Arbitration Convention. This makes arbitration an attractive option for cross-border franchise disputes, as arbitral awards can be generally enforced and recognized in Thailand. As for termination rights, there are no specific statutory limitations on the right of a franchisor or franchisee to terminate a franchise agreement. Termination rights are governed by the terms of the agreement. Liquidated damages clauses are generally enforceable, provided that they are reasonably proportional to the actual damages. There's also no mandatory minimum notice period for termination. However, and this connects back to the TCCT guidelines, which we discussed earlier, it is important that the terms must be fair. So termination provisions will be scrutinized if they appear to be exercised in a discriminatory or unjustified manner. As for non-compete and non-solicitation, in terms of interim and post-term non-compete and non-solicitation covenants are enforceable in Thailand, so long as they are not excessive and do not place undue burden on the other party. Okay, and we have a few more here. Withholding tax. For international franchise arrangements, franchise fees and royalty fees paid by Thai franchisees to overseas franchisors are generally subject to tax income in the form of withholding tax at a rate of 15%. Importantly, the Thai Supreme Court has held that marketing and advertising expenses are required by the franchisor, and required by the franchisor may also be deemed part of the franchise fees and therefore may be subject to withholding tax, even though those expenses were not paid directly to the foreign franchisor. This is a planning issue that needs careful attention. As for foreign investment, foreigners are generally permitted to start businesses in Thailand, but the Foreign Business Act restricts the type of business that may be conducted by foreigners and sets licensing requirements. There are various investment schemes, such as those administered by the Board of Investment, that operate as exceptions, and several free trade agreements may also provide pathways. Each of these areas includes nuances and interdependencies that can significantly affect the success of your franchise arrangement. The specifics will, of course, vary on your industry, your business model, and the structure of your franchise network. And with that, let me hand back to Gassama, who will walk through recent TCT decisions.
Thank you, Cherayaporn, for the brief on the law part. So now that we have seen the legal framework, the regulatory guidelines, and the IP requirements, as well as the key considerations for contract drafting for franchise, we would like to show you how this is playing in practice through the decisions of TCCT, who has been handling down over the past few years. In the absence of a dedicated franchise statute, these decisions provide practical guidance on acceptance of acceptable franchisor conducts in Thailand. Over the past few years, the TCCT has decided on a series of disputes spanning coffee, bubble tea, parcel delivery, automotive dealerships, and convenience retails. Together, these decisions are beginning to map with some more precision where legitimate brand stewardship ends and where an abuse of superior bargaining power begins. Let me walk you through some of the key themes. Post-contract changes. One question that comes up frequently is whether a franchisor can change the terms after the contract has been signed. The TCCT has made clear that midterm changes are not automatically unfair. What matters more is whether the franchisor has a legitimate business reason for the change, and whether franchisees were given advance notices, and also whether the process was handled transparently. A good illustration is a 2023 coffee franchise case where the franchisor raised raw material prices after the contract has been signed. The TCCT accepted this because the franchisor has announced a price adjustment in advance, and the increase was driven by genuine cost pressure in the market. So for the franchisor, the practical test comes down to three questions. Is there a real business justification? Was advance notice being provided? Were the franchisees treated fairly throughout the transition? Similarly, the TCCT has confirmed that purchasing restrictions such as product tying, bundling, or conditional sale may be permissible if it is justified and has been clearly disclosed. Again, what matters is whether there is a legitimate business reason, an advance notice was given, and franchisees were treated fairly. Let me now turn to discriminatory treatment. And here, a 2024 automotive dealership decision is particularly instructive. In that case, the distributor selected to invite only certain dealers to a confidential one-on-one meetings, gave the complainants only short successive contract renewals, and ultimately declined the renewal. So all without ever publishing any transparent selection criteria. The TCCT held that this constituted a refusal to deal with reasonable costs and imposed administrative fines on both the distributor and the individual members of its management committee who were responsible. The takeaway here is clear that if you are a franchisor or a distributor, your selection criteria for renewals, terminations, and access to the network information must be transparent and have to be applied evenly across all partners. Now, territorial encroachment is commercially one of the most sensitive issues in franchising, and the TCCT has addressed it head-on. In 2024 parcel delivery franchise decision, the TCCT found an abuse of a superior bargaining power where the franchisor opened its own company branded outlet as close as 50 meters away from the existing franchisee location, allowed other franchisees to open new outlet roughly 700 to 800 meters away and charge lower shipping rates at the company outlets. All of these without giving prior notice to the affected franchisees. The TCCT ruled that franchisor must provide at least 30 days notice in advance to the nearest existing franchisee before opening a new outlet in their area, and must give the franchisee priority to open the new branch themselves first. This builds on an earlier decision in 2021 involving similar facts, where the TCCT went further and imposed personal liability on the sole authorized director of the franchisor. So the message is unmistakable that territorial fairness matters, and franchisors who ignore this may face consequences. Finally, it is important to remember that not every franchisor action that hurts a franchisee is considered unfair. In February 2025, bubble tea franchise decision, the TCCT upheld the franchisor's termination, where the franchisee has used unauthorized ingredients, sold products outside the scope of the franchisor's trademark, and actively promoted a competing business through social media. The TCCT confirmed that strict adherence to the brand standards and contractual exclusivity obligations remain decisive. When a franchisee breaches these core commitments, the franchisor has every right to terminate. Now, we have only scratched the surface of the decisions. Each one involves a specific set of facts and circumstances that determine the outcome. The point we wanted to emphasize today is that the TCCT is actively shaping the franchise norms in Thailand. These decisions affect how you should now draft your agreements, how you should manage your franchise network, and how you handle disputes. Understanding this guideline and structuring operations accordingly is essential to the franchise business currently. Now let me shift from the principles to the practical considerations for both franchisors and franchisees. What should franchisors and franchisees actually be thinking about when structuring and entering into franchise arrangements in Thailand? So there are two different perspectives from both the franchisor side and the franchisee side. For franchisors entering into the Thai market, the first thing that you need to consider is intellectual property protection that my colleague has earlier described. Trademark registration is fundamental. You should register your marks in Thailand before launching your franchise program. Equally important is any trademark license agreement must be recorded with the Department of Intellectual Property to be enforceable, as an unrecorded license is going to be considered void and invalid. And recordal must be in Thai, so factor in the translation time and cost. Secondly, you have to think carefully about your franchise structure. Foreign ownership restrictions under the Foreign Business Act may apply depending on how the franchise business is characterized. Most foreign franchisors operate through a Thai franchisee or master franchisees rather than establishing their own real presence here. If you are considering a direct presence, you need to evaluate whether the Board of Investment Incentives or the U.S. Thai Treaty of Amity, if you are an American company, might provide a pathway. Thirdly, you need to adapt to local preferences. This applies to everything from menu localization for food and beverages brands. Think about rice dishes at McDonald's or spicy chicken at KFC in Thailand, to marketing messages that resonate with Thai consumers. Cultural missteps can hurt even the strongest brands. Fourth, be prepared for the tax implications, because franchise fees and royalties fees paid by the Thai franchisee to overseas franchisors are subject to 15% withholding tax. Marketing contributions that franchisees are required to spend on advertising the franchisor's brand may also be characterized as part of the franchisee fee and are subject to the same withholding tax, even though the money was never passed directly to the franchisor. For the perspective of the franchisee, you should conduct thorough due diligence before signing an agreement. While Thai law requires franchisors to provide pre-contractual disclosure covering fees, business model, IP rights, renewal and termination terms. There is no specific or prescribed format or timeline or formal approval process. The quality and completeness of the disclosure can vary significantly. So franchisees should independently verify the franchisor's financial standing, the viability of the business model, and the status of the IP registration in Thailand. Franchisees should pay close attention to renewal and termination provisions. Thailand does not have specific laws, statutory limitations on termination rights. Everything turns on what the contract says. So understand exactly when and how either party can exit. What happens to your investment if franchisor decides not to renew? And whether you have any rights of first refusal if franchisor wants to expand in your vicinity. You have to know all that. And remember that if the underlying trademark registration expires or is cancelled, the license automatically ceases to have effect under Thai law. So make sure that your franchisor is maintaining its IP registration. Now we would like to summarize the key points to keep in mind when you navigate franchising in Thailand. First, the absence of a dedicated franchise statute in Thailand might initially seem like makes things simpler, but in reality, it may make things more complex because the rules are distributed across multiple laws, across different regulatory guidelines, and also there is an evolving body of TCCT decisions that we discussed earlier. Each franchise agreement is unique and the applicable rules depend on your specific industry, business model, IP portfolio, and franchise network structure. Getting it right requires careful contract drafting and anticipates the interplay between competition law, intellectual property law, and commercial law. It requires an understanding of the franchising guideline and how the TCCT is interpreting them. It requires proper IP registration, licensing, and recordal. It requires ongoing compliance, monitoring, and regulatory environment continues to evolve. That brings us to the end of the presentation today. Thank you again for joining us, and we hope to see you again next time.
Thank you.
Thank you.